Then it says the power of Parliament to make laws shall be limited to those matters in the Union and the concurrent list which in the consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession. So this was on the issue of the legislative lists and that schedule. Matching them with our 7th schedule, and the President would decide how the 7th schedule is to be divided. And here it's only consultation consistent with the philosophy that accession and instruments of accession, these are what are in international law called political documents, not political in the political sense.
I think, Mr. Salve, it's very clear now. If the President wanted to make any exceptions or modifications,
yes,
in respect of defense, communication, or external affairs, then only consultation was required.
Correct. Now, my lord,
of the first proviso to clause D.
Correct. Now, my lord, applying other provisions of the Constitution, and my lord, I don't have to give your lordships a catalogue of which are the other provisions. I mean, there are so many important provisions of the Constitution. They would be phased in and applied under D.
Right.
And for that, they said concurrence.
They would require concurrence.
They would require concurrence.
They referred to either defense,
correct.
The
legislative lists,
affairs or communications.
Broadly, let us say the legislative lists are put to one side because that is really power to make laws. Yes. But for institutions, your lordship's jurisdiction under 32, for example.
The Constitution also, yes.
Your lordship's jurisdiction under 32. Should it extend or should it not extend to Jammu and Kashmir? These are, and what about public service commissions? What about election commissions? So on and so forth. So all those were provisions to be applied if necessary with adaptation. Now, what is important? And I come back therefore to my point. How does this align with a complete accession? Article 3 is the answer. That this is an arrangement for the phased introduction of the Constitution, keeping or reserving unto the President the power to disapply this article. Now, obviously, for that, there cannot be concurrence. So it makes sense. Recommendation if there is a Constituent Assembly, otherwise the action of the President. This was the arrangement, this was the compromise. And my lord, this compromise was not just with the state of Jammu and Kashmir, the solicitor has placed before your lordships the sharp differences of view even in the Congress Working Committee. They rejected this plan. First time when Shri Gopal Ayangar presented it. Sardar Patel's letter is cited in the solicitor's list of dates. He said, sorry, I don't accept these. So this was a very matter with more than one point of view and competing points of view. So this was the compromise formula, which is incorporated here in the Constitution. This was the workable arrangement. This is all right. Ultimately, we will decide and we will keep to ourselves the power to disapply this article. But if this works phase by phase, introduction of the Constitution, why not? And it did work to a large extent. So one of that principle, which my lord the Chief Justice was pleased to put to me, about lesser power and larger power, would it not require greater safeguard? That would not occur. That's what I call the contextual argument. I'm not finished with this, and I have eye on the clock. If there's anything more, I can assist your lordship on this point. Otherwise, let me move to my next point.
You can move. I think we can move to your next point, Mr. Salve.
Yes. Second point is, my lord, there has been some arguments about even if 370 applies, because no radical change. And Delhi laws was cited. Now, some cleaning up, because some principles need to be clearly stated. The Birla cotton mills in read Delhi laws, the power to extend laws. You cannot make a radical change. But that can have no application here. That principle can have no application here. Because your Lordship has seen those cases. Your Lordships read down the power to extend and apply laws under Article 14. The argument was excessive delegation. You have conferred upon the executive the power to change a law made by Parliament and its application. And that is why your Lordship said we read it down. That the philosophy, the basic policy of the law cannot be changed, radical changes cannot be made. My Lord, 370 is a part of the Constitution itself. There is no question of excessive delegation. This is a power conferred on the President. And that is why my Lord Lakhanpal rejects this approach. But I was giving your Lordships an answer on first principles.
Yes.
The power, my Lord, under 370 is plenary in nature. And this is a power conferred by the Constitution. A plenary power is not subject to the principle of, or is not amenable to a challenge of excessive delegation, because the Constitution has made this delegation. Where Parliament makes a law which is subject to Article 13, or where the state legislature makes a law which is subject to Article 13, then an Article 14 challenge can be brought saying this is excessive delegation. And all the Delhi laws, in Delhi laws downwards cases, all dealt with excessive delegation. In statutory provisions on the anvil of Article 14, it is completely irrelevant to 370. Your Lordship has already said this in Puranmal, but I wanted to just put it on first principles.
Yes.
The second, my Lord, point is that the power exercise is legislative in character. I don't think I need to belabor that point very hard. Applying provisions and disapplying provisions, modifying provisions of a law is legislative in character. I don't think I need to cite authority for that matter. To suggest that this is an executive power is like saying ordinance making is executive power. And it is done by orders, Malad. I'll just give you a Lordship a citation. The Meghalaya case with Schedule 5, for example, of the Constitution. 1972, one Supreme Court case is 148, just for reference, where your Lordships have said that, because there also the President can by order say this and by order say that. You're not saying. So this is now what follows from a plenary power and a power which is legislative in character. It has a direct bearing on the next issue of the extent of judicial review, of the exercise of that power. Because that logically takes me to my next point, that the Ajit Mills principle, as Justice Krishna has explained in Ajit Mills. In the context of a law made by Parliament, if you say this is abuse of power or colonial legislation, it's an argument of competence, not of motive. That is not the Ajit Mills principle. Your Lordship knows when the first law was made, saying if you've collected illegal sales tax, which is not chargeable, if you've collected, you pay. The argument was this is tolerable legislation because you're taking away. And Justice Krishna's answer, I'll just give the page and para numbers, 77-4 SCC, page 98. This is attached to my note. This is attached to my note starting from page 6. Page 4, sorry. And the relevant paras.
But Mr. Salve, even if it is a legislative power,
Yes,
as you say it is, and probably it is, it's amenable to judicial review on the ground of Article 14. A legislative power cannot be challenged on the ground of malafide. For instance, you cannot
exactly.
say that Parliament did something because of a malafide intent, because you don't attribute malafides to a collective body of individuals. That's the reason for
That's correct. More than that,
Nagaraj, when they reduced the age of retirement, our court said you can't challenge the reduction in the age of retirement on the grounds that Parliament was acting malafide, because it's a collective body. Malafide is something which you attribute to an individual.
More than that, my lord, your lordships have always said, where it comes to colorable device, supplementary, and all these, as it is not explained in this judgment,
Actually, they started that.
It is really a competence argument.
Colorable exercise of power in Tulloch, our court said, it really means that though you are purporting to exercise power under one entry, you've actually transgressed into another entry. So it's really a question of absence of power, legislative.
It's a competence argument.
It's a competence argument.
Yes. It's not the Wednesbury unreasonableness.
But equally, Article 14 would be attractive.
But 14
meet the test of Article 14.
But 14 can have no application to an Article 370 sub-Article 3 situation. Of course, legislative power you can. If you make a rule which is plainly discriminatory, you can strike it down on violating 14. Of course, because if Article 13 applies, the whole panoply of fundamental rights apply.
But therefore, assuming that this is a legislative power, it is not immune to challenge on the ground of violation of fundamental rights.
Correct. Fundamental rights, whether a 370 sub-Article 3 disapplying Article 370 is at all amenable to fundamental rights, question mark. I'll address your lordship for a minute on that. Because this is a relationship between the union and a unit of that union. We are now units of that union.
They may be parts of that relationship which create rights in favor of individual citizens.
But if it affects an individual,
a classical part of that, the provision of the on the right of residence. An individual, for instance, can say that I and people belong to my class have the exclusive right of residence in this state. By bringing in others, you are affecting my right under Article 14. Whether there is substance or not is a different thing altogether. But it's amenable to that challenge. You can't say that the challenge is immune.
My lord, I would respectfully submit, applying or disapplying the constitutional provision would not give a individual citizen a right. Because I'll tell your lordship, this takes us back to the basic principle of this is adjusting the accession. Now, my lord, in international law, for example, a citizen can never assert that I had certain rights under an earlier legal regime, and now there is an accession, those rights should be continued. Your lordships have rejected that, consistent following the principle of international law. You have only such rights as are available to you within the territory. Now, in that, if there is a discrimination, you can challenge. Today, my lord, which constitutional regime will apply in Jammu and Kashmir is more, in one sense, almost a constituent power. So, my lord, Article 14 challenge on the ground that I was a citizen, I was living in Kashmir, nobody else was allowed to enter here, now you've taken away my rights. That argument will not be open.
That's quite apart from, of course, the submission of the solicitor that by the abrogation, you expanded the panoply of rights which are individual, which an individual in Jammu and Kashmir has. You have not
I'm not taking an extreme case. Can an individual come and say, I had a right to live here, splendid isolation? You've taken away that right, and now all Indians have the rights, which I earlier had as a special right.
Your contention is that the residents' right to live in Jammu and Kashmir is not taken away.
Nothing. Their rights are expanded by applying the whole of the Indian Constitution. Nobody has a vested right in a state of governance in that sense. And Malad 370 is a part of the Constitution where the president has a power to disapply the Constitution. If he disapplies the Constitution, how can a citizen complain? A resident of that state. As much as a resident of outside Kashmir could not say, why am I made subject to parliamentary legislation when this subject in the state of Jammu and Kashmir is not? And in fact, Malad, we used to always, I remember the late Altaf Ahmad used to always have a little joke. He says, you people have lost the right to property, we haven't. 19 continued, the equivalent continued under the Jammu and Kashmir constitution. We got rid of property rights. Now, could an Indian complain, could a person outside Kashmir, a fellow Indian, say that my fellow Indian there in Jammu and Kashmir has a right to property? If you take his property, you have to pay him full compensation. But if I am outside Jammu and Kashmir, take my property and you can show me a blank piece of paper and there's nothing I can do.
370 now leads to the abrogation of 19(1)(f) in Jammu and Kashmir.
It does.
But which is not a part of the basic structure. 19(1)(f) has been held not to be a part.
It is not as much today. If you are creating a larger equality, the solicitor has developed this point, you've created a larger equality. Where is the question of violating 14? And individuals, Malad, that principle must be extended. Your lordships have dealt with this problem, where the argument was there were prior leases. Your lordship said, sorry, post-accession, you have what the law gives you. You have nothing else. Now, if post-accession...
Actually, we need not really explore this line
exactly.
much for the reason that this might have impacts on other parts of the Constitution.
That's why, Malad, I was...
The Constitution which creates rights in favor of specific groups.
Yeah, Malad, that is why I limited myself.
Whether they're based on religion, whether they're based on caste, on marginalization. So to say that by obliterating that right, you're not affected by a larger equality, maybe.
Malad, 370 operates.
If we accept it in that broad sweep.
No, Malad, that is why I'm saying 370.
Because I don't know what the ramifications.
No, Malad, 370 operates in a very narrow area. Very narrow area. It operates in the context of the compromise formula put in place for Jammu and Kashmir at the time of accession and at the time of its integration into India, etc., etc. And this power was kept to disapply this one provision, this special arrangement. Now, my lord, there is no equivalent in the Constitution. So we needn't go, my lord, the Chief Justice is saying the danger in getting into constitutional propositions in one context and making broader observations, my lord, we don't know what you are trampling underfoot for the future. My limited submission was the principle of limiting delegation by statute, which comes from Article 14, can't apply. This radical change is a reading down of the power to extend laws.
That point you have made, Mr. Salve,
That's the only point which I was making. The second point I was making was
restricted to that level. There is no difficulty.
That's all. And the second point which I was making was, my lord, that here abuse of power is really a power of competence.
And nobody has challenged the provisions of clause 3 of Article 370. That is
which, my lord, in fact brings me
part of the original constitution.
In fact, my lord, which brings me to my next point. And I'm going quickly now, because your lordship has seen the point. That this repeated reference to basic structure, my lord, quite frankly, even in some of your lordship's judgments, I find a little surprising. Basic structure was not a principle as an independent standalone constitutional right. Basic structure is the limitation inherent in 368. And constitutional amendments are tested with reference to the basic structure doctrine. But there are some judgments which do say this law not only violates 14 but violates the basic structure. Laws, strictly speaking, if you
don't violate the basic structure.
Laws can't violate basic structure. Laws violate part 3 or don't violate part 3.
You know, in 2 judgments, though, we have said that a particular law protects the basic structure. One.
But laws are aligned with the basic structure.
Places of Worship Act in Ayodhya, we said that is in pursuance of the...
Correct. Laws...
The second, we said that the amendment to the introduction of the amendment for Delhi in 239 AA was in furtherance of the basic structure, which is...
furtherance of basic structure...
So there's a little bit of...
let me try and, in my very humble submission, when a law is made to protect civil liberties, 21 is a part of basic structure. A law made to protect civil liberties is a law aligned with Article 21 and therefore aligned with the basic structure. Now, one may in a flourish of language say it is to further. Today, if there are checks and safeguards built into arrest, checks and safeguards built into criminal trials, etc., etc., you may say this is to protect the basic structure, because the basic structure is the trilogy of rights. Now, that is not to say that the law was tested on basic structure.
That distinction you've made, yes, of course, because as a doctrine, it was evolved to test the validity of constitutional amendment.
The problem is, my lord, one thing is to say something is aligned or not aligned with the basic structure. But to say that an exercise of power under 370 can be tested on the basic structure doctrine, I submit is a misconception. 370 itself is a part of the original prestige constitution. And that confers the power to disapply the constitution, the arrangement. If I am right on competence,
anything else, Mr. Salve, now?
So, my lord, that is the basic structure point.
Yes.
And the point which we have therefore already made And I close with that submission. How would your lordship interpret this? The nature of the provision is such, if it confers plenary powers, not in the field of civil rights, not in the field protected by Part 3, but in the area of governance and in the area of constitutional adjustments, your lordship will give it the widest possible. Because the idea is never to hedge in future generations by reading the constitution narrowly. That is a well settled principle. Last point which I have to make, my lord, is if we are wrong on this, the 356 test. Can a change of permanence be made when a 356 regime is in place? It has two answers. I'll just take 2 minutes on this. This is no longer res integra, my lord. Your lordships have right from Rajasthan and Union of India, Bomai chiseled this law and said, up to the stage where Parliament approves, don't do anything which is irreversible. Thereafter, you may. Because everything in one sense is irreversible. What Parliament does is also irreversible. Parliament passes the budget for the states. It takes over the coffers of the state. What money is spent is irreversible. The money is gone. But that's the way it is. The president may not dismiss people, appoint people, create institutions, remove institutions. The governor may do, the president may do under 356. Those are for those people irreversible actions. That is why your lordship has said 356 is draconian and should be very sparingly used. If the unfortunate circumstances require that for a defined period of time, the system of governance is changed under 356, if those unfortunate circumstances exist, and a very narrow area of judicial review is permissible, it doesn't arise because there is no challenge before your lordship, a bald prayer without the necessary averments, the challenge. Then, my lord, one is to accept the consequences of 356. But that's in the alternative. If I am right on my construction, my lord, of the proviso, quite frankly, minus the Constituent Assembly, it fell away. So you just added the state legislature and then you acted for the state legislature. Nothing my lord, dramatic really happened. If one ignores that also, if we are right on the proviso, then none of those questions arise. That, my lord, is the submission, unless